Hello, everyone. Welcome to our Enterprise Agreements and Unions webinar this afternoon, presented in collaboration with AiGroup. The purpose of the webinar is to give growers an essential guide to undertaking an enterprise agreement in the current industrial relations landscape. The webinar will also talk about why growers should consider an enterprise agreement. As we know, there has been a lot of discussion about this in recent weeks, given the recent union activity in Victoria. The webinar is presented with Vikki, Sultana, who is a Principal Advisor, Workplace Relations at AiGroup Workplace Lawyers. So welcome, Vikki. Vikki graduated with a degree in law and has an extensive experience in workplace relations across private enterprise, government, and with peak industry bodies prior to joining AiGroup. So I'd like to welcome Vikki and look forward to this webinar. Thank you.
Thank you, Lucy, and thank you everyone for joining us today. Today, I've been tasked with speaking to you about enterprise bargaining and in particular, contentious bargaining. I understand that the Australian Industry Group has already delivered a webinar on the enterprise bargaining process, including certain timelines and key events that need to be complied with under the Fair Work Act in order for your agreement to be approved. Now, I don't intend to labour the point of that material today, although you will likely find the content of today's session is better contextualised if you've previously listened to the earlier webinar or reviewed the related fact sheet. The point of what we're going to discuss today is more of a practical hands-on guide to enterprise bargaining, and in particular, some guidance on how to manage enterprise bargaining when things aren't going to plan. For example, when you're contending with disputes or protected industrial action. We'll have plenty of time for questions at the end of the discussion. I've allowed roughly 15 minutes for an open forum, but please don't hesitate to interject or ask a question at any point throughout today's discussion. All right, let's go. Is that going to scroll down for me? Oh, there we are. Agenda. Perfect. All right, so we're going to cover off a number of key considerations in contentious bargaining. We'll start off by considering the benefits to growers of an enterprise agreement and how to prepare for and manage the enterprise bargaining process. In particular, we'll consider how to manage enterprise bargaining disputes and protected industrial action. We'll then move on to discussing a particular form of protected industrial action known as strike action. We'll look at ways to avoid, plan for, and manage that type of action. We'll also discuss the importance of engaging with your workforce during the enterprise bargaining process, why two-way communication is important, and how you can best communicate with your employees. We'll look at when the union can bargain on behalf of your employees and the rules and requirements that they need to follow in order to enter your site for the purposes of holding discussions with your employees. Finally, we'll have a brief chat about some of the options for outsourcing the enterprise bargaining process. Seeking professional help, whether that's engaging someone to act as your bargaining representative or simply to stand on the sidelines and provide support to your business as and when you need it. All right, so we'll start by considering the benefits of enterprise bargaining, both to growers and their employees. So why have an enterprise agreement? What's in it for me? Look, these are fairly common questions that most employers in most industries will ask when considering whether to initiate bargaining. Now, there are a number of different benefits to an employer to having an enterprise agreement in place. Probably the most pertinent consideration is this. One of the biggest benefits of being covered by a single enterprise agreement or being in the midst of negotiating for a single enterprise agreement is that you can't be pulled into multi-employer bargaining. When discussing with employers their strategies for avoiding multi-employer bargaining, Our advice is often that the best coverage an employer can afford themselves in this respect is to have a current single enterprise agreement in place. There are a number of other benefits to growers to having an enterprise agreement. For example, you have employment terms and conditions that are tailored to your business, for example, around rostering and hours of work. You have certainty as to remuneration costs and the option of incorporating penalty rates and allowances into a single loaded rate in order to steamroll your payroll processes. You have certainty on future wage growth. That is, you have predetermined wage increases for the nominal term of the agreement. If multiple awards cover and apply to your employees, you can consolidate and simplify their terms and conditions of employment. Having an enterprise agreement also reduces the risk and number of workplace disputes, particularly if unions have been involved in the bargaining process. And finally, an enterprise agreement will afford you a competitive advantage when tendering for work because you can fix your costs. What are the benefits to an employee of having an enterprise agreement? Largely, employees are empowered by the bargaining process. They enjoy certainty as to their employment terms and conditions, and they're assured that they're better off under the agreement than they would have been under the applicable award. All of these incentives may result in increased productivity and morale among employees. Are there any disadvantages for growers to having an enterprise agreement? For the most part, I don't know that I would call them disadvantages, but rather they're factors that have an impact on a grower's time and to some extent costs in terms of the process involved in negotiating an enterprise agreement from start to end. An agreement takes time to plan, create, and negotiate, and this can be costly. An agreement requires a strict process and timeframes that must be met, or the agreement may not be approved by the Fair Work Commission. The employer has limited control over the voting outcome and, of course, the involvement of unions. The termination of an enterprise agreement usually requires agreement of the employees. And if you want to vary an agreement before the nominal expiry date, you'll need to seek agreement from employees and approval from the Fair Work Commission. Alternatively, an enterprise agreement can be terminated by mutual agreement between the employer and the employees. Preparing for and managing the enterprise bargaining process. When should I start preparing for enterprise agreement negotiations, and what are the types of things that I need to think about so that I'm on the front foot from the get-go? Believe it or not, I recommend that if possible, you start planning for your negotiations at least 6 months prior to the commencement of those negotiations. Why such a long lead-in time? Well, there's quite a bit of work that needs to be done from the growers' end before you even sit down with your employees and the unions. Growers need to have a clear understanding as to what it is that they're seeking and why they're seeking those things. You also need to have a clear order of priorities in relation to your claims. For example, which of your claims are absolutely non-negotiable and essential to your business operations? Which are nice to have, but not essential and not worth dying in a ditch over? And which are really just the icing on the cake? You know, those aspirational claims that we throw into the ring for the sake of having a go. But at the end of the day, they're the claims that we'll ultimately let go of for the sake of letting the unions feel like they've secured a win. So look, you can see there's a degree of strategy involved in enterprise bargaining, even from the start. In order to prepare adequately for these negotiations, you'll need to devise a plan to avoid any nasty surprises. So, for example, When you're preparing your log of claims, if you don't currently have an enterprise agreement in place, it's a good idea to use the relevant modern award as a starting point or a baseline by which you can assess the types of claims that you're considering against the industry baseline. You should select a negotiating team early on, and you should assign specific roles and scripts. Your team should be composed of line managers and leaders and a subject matter expert. So someone who's an industrial relations or workplace relations expert. Before preparing your log and when considering the union's log, consult with your line managers and actively encourage feedback from them. Remember that these are the people who will have to implement any changes that you agree to. Identify which issues and parts of the business are impeding productivity, customer service, etc., and need to be improved. Write down your log of claims and prepare scripts that set out your position. And think about how you want to present your log of claims. For example, you could have a table that sets out the existing clause on one side, the proposed new clause on the other side, and then includes some reasons for making the change. You should also be thinking about your fallback position if the unions won't agree to your primary claim. For example, would you be willing to rely on the award clause instead? Finally, you need to analyse what your stakeholders, so employees and unions, etc., want and why. Prepare the business's position in relation to each and every one of the union's claims and also what your fallback position is. This level of preparation will really help you when you get into the negotiating room. All right. So we'll just pick up where we left off. So preparing and planning. So we've consulted with our leaders and managers. We've developed our log of claims and we've considered the log of claims advanced by the unions and employees. What happens next? And more importantly, how do we manage the negotiations so that they stay on track? One of the biggest issues businesses have with enterprise bargaining is that the negotiations become unnecessarily protracted because the parties lose track of the important issues that need to be discussed and often end up going down wormholes and discussing matters that are largely irrelevant. This delays the enterprise bargaining process and can be a frustrating waste of time. A question that I'm often asked is, how long do the negotiations need to go for? Or how many meetings do you think we'll need to reach an agreement? Probably the best way I can answer this question is to say that the duration of your negotiations will be determined in large part by the degree of planning that's gone into the process, the complexity of the matters to be considered, and the willingness of the parties to approach the negotiations with a vision of compromise in mind. Now, generally speaking, most negotiations will run for anywhere between 6 and 12 meetings. Meetings typically occur on a weekly or fortnightly basis. My preference is for weekly meetings, and that's in order to avoid the need to spend the first half of each meeting recapping on previous discussions. If your meetings are going to run for more than 2 hours, I recommend that you incorporate periodic breaks to allow people to cool off and avoid frustrations running too high. On the slide, I've listed some simple things that you can do to help keep your negotiations on track. So issue a short agenda prior to each meeting and ensure that the discussions are limited to the items on the agenda. Have a note taker in your meetings and issue minutes following each meeting. Your first agenda item at each meeting should be to affirm the minutes of the previous meeting. This avoids he said, she said debates down the track. Set a bargaining period and schedule meetings, allowing sufficient times for difficult meetings and complex issues. Set guidelines for the conduct of the meeting. It can be as simple as one person speaks at a time, etc., that type of thing. And these guidelines should take the good faith bargaining requirements in the Fair Work Act into account. Engage directly with your people, both to build trust and prepare them for the changes. For example, by improving their knowledge of how the business operates and what shape you're in financially. Don't leave employee communications exclusively to the union. If you do, you'll be on the back foot. You need to be running your own campaign. Otherwise, the only version of the story that your employees will hear is the union's. Look for early wins rather than tackling difficult issues first. Document all meetings, agreed clauses, and key developments with copies sent to everyone involved. Keep your employees informed of developments. And finally, when you do reach an in-principle agreement, engage an expert to either draft the agreement that you've prepared or to put something together for you from scratch, depending on your resources. Bargaining disputes. So what happens when we've reached an impasse in our negotiations and we're not getting anywhere? Neither party is budging. Whilst negotiating a new enterprise agreement, a bargaining representative, such as a union, can make an application to the Fair Work Commission to deal with a dispute about the agreement. Applying for the Commission to deal with a bargaining dispute can be a way to advance negotiations if the bargaining representatives have reached an impasse or deadlock in their negotiations. Although strictly speaking, it's not necessary to have reached a deadlock before seeking the Commission's assistance. Approaching negotiations with a take it or leave it attitude will very likely lead to either a bargaining dispute or protected industrial action. Enterprise bargaining is a fluid process. It involves give and take on both sides. The Commission may deal with a bargaining dispute as it considers appropriate. This can include mediating or conciliating the dispute, or making a recommendation or expressing an opinion. Previously, if the Commission was unsuccessful in its attempts to assist the parties to resolve the dispute, there wasn't really any further form of recourse for the aggrieved party under Section 240 of the Act, unless both parties agreed to have the Commission arbitrate the matter. This often meant that the next logical step for an aggrieved party was protected industrial action. However, changes to the Fair Work Act now allow a greater opportunity for the Commission to become involved in protracted bargaining disputes that would otherwise be unlikely to resolve without intervention. Specifically, the amendments that I was just referring to the Fair Work Act empower the Commission to make intractable bargaining declarations and intractable workplace declarations to deal with ongoing and unresolved bargaining. Now, this expands the power of the Commission to intervene in bargaining disputes and arbitrate workplace determinations when the parties can't reach an agreement. So essentially, that's an industrial instrument created by the Commission, which sets wages and conditions. That's what can now happen. Now, under the previous regime, workplace determinations could only be made in limited circumstances, and this occurred very rarely in practice. The change allows the Commission more scope to intervene in long-running bargaining disputes and, if necessary, bring the bargaining to an end by making a determination. If an application for a declaration is made by a bargaining representative, whether an employer or a union, the Commission may make the declaration if it's satisfied that it has previously dealt with a bargaining dispute about the proposed agreement. So you've gone through that Section 240 dispute process. There's no reasonable prospect of agreement being reached if the Commission doesn't make the declaration. The minimum bargaining period has passed, so that's 6 months after the nominal expiry date of any existing agreement, or if there is no existing agreement, 3 months after the bargaining dispute was first notified to the Commission. And it's reasonable in all of the circumstances to make the declaration, taking into account the views of all of the bargaining representatives to the agreement. All right. The other option that may be available to the parties when negotiations reach a standstill is protected industrial action. Look, the starting point is that the Fair Work Act says that protected industrial action is legal. Employees can take protected industrial action when bargaining for a new enterprise agreement fails and the existing agreement is out of date, so it's past its nominal expiry date. To take protected industrial action, employees need to apply to the Fair Work Commission first. If the Commission approves the application, they'll make an order to permit the employees to organise a protected action ballot, so a vote. This means that all of the relevant employees, usually union members, if it's the union that's made the application, will be given an opportunity to vote on whether they want to take protected industrial action. You can see from the flowchart on the slide that industrial action isn't something that can simply happen overnight once the Commission approves a protected action ballot. The vote itself needs to be organised. This involves the applicant, usually a union, preparing a roll of eligible voters and organising the vote with the relevant ballot agent. Once the vote itself has taken place, if the employees vote in favour of protected industrial action, they need to provide written notice of at least 3 working days to their employer before they can commence any protected action. So that's in respect of a single enterprise agreement. As part of this process, the Commission will also make an order directing all bargaining representatives to attend a compulsory conciliation conference during the ballot period. Now, if an employee bargaining representative doesn't attend the conference, then the employees that they represent are not permitted to take protected industrial action. So what exactly is protected industrial action? Is it just strike action or does it include other things? On the slide, I've included an example of the type of questions that will often be put to employees when voting in a protected action ballot. As you can see, the questions don't just relate to what we typically understand to be strike action. Protected industrial action can be in the form of strikes, stoppages of work, and bans. For example, a ban on working overtime or driving a tractor or using a particular piece of plant or equipment. In order for employees to be able to take a particular form of protected industrial action, there must be a majority vote in favour of that particular form of action. So, for example, question 2 on the ballot on the slide says, do you vote in favour of an unlimited number of bans or limitations on the processing of paperwork? Unless the majority of employees vote in favour of that particular course of action, it can't be taken. Where an employee takes protected industrial action, do we have to pay them? The Fair Work Act provides that during a period of protected industrial action, it's actually unlawful for an employer to pay an employee. Where employees are striking or stopping work, they must not be paid in respect of the period of action. Where employees are engaging in partial bans, for example, if employees are refusing to operate tractors, then they're only entitled to part pay. So the employer needs to decide in advance what percentage of the employee's role the ban relates to. So, for example, if driving a tractor composes approximately 25% of an employee's job, and the employees are engaging in a ban on tractor driving, then their pay should be reduced by 25% in respect of the ban. Finally, who can take protected industrial action? To be eligible to take protected industrial action, an employee must be in the group specified in the protected action ballot order. For example, if a union makes an application, it will only be in respect of their members, and therefore only union members can vote in the ballot and take protected action. and employees must also be covered by the proposed agreement. So to be clear, if a union has made an application for protected industrial action, their list of voters can only include union members, meaning non-union members are not permitted to participate in the vote or take part in the protected industrial action. Another common question we get is, can an employer object to protected industrial action? The Commission can suspend or terminate protected industrial action in very limited circumstances. The Commission can make such an order when the action has threatened to endanger the life, personal safety, health or welfare of the population or a particular part of it, or to cause significant damage to the Australian economy or an important part of it. They can also make an order where the action is protracted and is causing significant economic harm to the employer and the employees who would be covered by the agreement, or a third party. Okay, so what exactly is the threshold requirement for the Commission to be satisfied that the action will threaten, endanger, or cause significant damage to the Australian economy or an important part of it? I think a good case in point is the Sydney Trains example. 3 or 4 years ago now, Sydney's train drivers sought to take protected industrial action in the form of a strike in order to advance their wages claim in their negotiations with Transport for New South Wales. One of the unions, I think it was the TWU, made an application for protected industrial action, and the government objected to the granting of the application on the basis that if the train drivers were to strike, the industrial action would cause significant damage to an important part of the Australian economy. Specifically, the government argued that the proposed action would cause the Sydney public transport industry to come to a complete halt and enter a state of complete and utter chaos. It was argued that the strike action would propagate significant health, safety, and welfare concerns for a significant portion of the population, and as a result, the industrial action shouldn't proceed. Now, the Commission ultimately agreed with the government, and the train drivers were precluded from taking protected industrial action on that basis. Now, this gives you an indication of how high the threshold is in order for the Commission to suspend or terminate protected industrial action. Employers who go to the Commission and argue that protected industrial action should be suspended on the basis that it will cause significant economic damage to their business alone probably won't succeed. On the other hand, if the industrial action is widespread and will cause significant damage to an entire sector of the Australian economy, that claim might have greater prospects. For example, if protected industrial action was going to prevent the distribution of potatoes by all growers to all Australian supermarkets, this would be a form of action which, in my view, would cause significant damage to an important part of the Australian economy. However, if one grower is precluded from delivering potatoes for a limited period of time, this alone probably won't meet the threshold required for the Commission to suspend or terminate protected industrial action. All right, before we take a look or dive a little deeper into protected industrial action, let's look briefly at what constitutes unprotected industrial action. Unprotected industrial action is action that is taken before an agreement has reached its nominal expiry date, without a successful ballot, to include unlawful terms in an agreement, or as part of patent bargaining. It also includes actions that are illegal or not otherwise authorised under the ballot. The Commission can make an order on its own initiative or as part of an application to stop or prevent unlawful industrial action, including by granting interim orders. As far as practicable, the Commission must determine an application for an order to stop industrial action within 2 days of the application being made. Now, despite the need for quick action, the Fair Work Act recognises that it may not be practical for an application to be determined within that 2-day period. So if the Commission is unable to determine the application within a 2-day period, it must within that period make an interim order that the unprotected industrial action stop or not occur or not otherwise be organised. Now, when it comes to active unprotected industrial action, including illegal actions such as blocking public roads, I appreciate that 2 days is an insufficient amount of time to have to wait for an order or an interim order. Later in this discussion, I'm going to talk you through some of the other options available to you for dealing with illegal unprotected industrial action. Okay, so, oh, my notes back up, there we are. We've looked at what protected industrial action is and how it's different to unlawful industrial action. Let's talk about how to avoid industrial action, or in the case that it can't be avoided, how to plan for and manage it. The best strategy, in my view, for avoiding protected industrial action is to keep your lines of communication active and open. Before things reach boiling point and a protected action ballot is filed, actively talk to your employees and talk to them directly. Put out employee comms which explain the commercial and financial limitations of the business. For example, if you have a contract with a big supermarket and that contract is for a fixed rate over a fixed period, explain that to your employees so that you're giving them some context to why you can't meet their demands in respect of increased wage rates. If the only form of communication your employees are getting is from the union, this isn't good because the only version of the story that they'll be getting is the union's version. If you can't avoid protected industrial action, then you need to have a contingency plan in place. For example, if there'll be a partial ban on the use of certain plant and equipment, train up other employees to operate forklifts, tractors, etc. Think about whether you have capacity to build up stock. Obviously, certain stock has a limited shelf life, but what stock, if any, can you start to build up? Talk to your customers, alert them to the possibility of industrial action. Give them a heads up as to potential supply issues. Make sure you're also talking directly to your employees. If you're only talking to the union, you've already lost employee support. You need to explain to them why you can't give them everything that they're asking for. Don't just say no. If your workforce are predominantly non-English speaking, think about engaging a translator so that you can produce your written employee comms in languages that are accessible to your workforce. Finally, the nuclear option, which is available, is to take your own form of protected industrial action as an employer and to lock out your employees. In very limited circumstances, do we recommend this as an advisable course of action. Ultimately, lockouts make employers look like the bad guys, even if they're not. I've never seen a lockout where an employer has walked away not looking like the bad guy. I also wanted to touch on very briefly some tips for dealing with illegal industrial action, such as blocking public roads. The first point of call in these types of situations is the police. Ultimately, your local area command may be reluctant to intervene in industrial action, even where it's unlawful. If this is the case, you need to escalate the matter further up the chain of command. For example, if you don't get any traction with your local area commander, go to your regional commander. You can also go to the media, local papers, and reporters. Technically, the police are under no obligation to enforce these laws. However, by involving the media, to a certain extent, you can persuade them into it. Also, if you think there's even the slightest possibility of violence erupting, this should be reported to the police, as this will get them to your site pretty quickly. If you know industrial action is coming, you can also speak to the police beforehand. Give them a heads up that you're concerned that there may be blockages to public roads, etc. If you ever find yourself in a situation where the police refuse to act in relation to illegal activity, you should report this to the police ombudsman. While it won't solve your immediate problem, it will certainly help the next time around to have that on record. Okay, on this slide, I've extracted some media publications from Workplace Express in relation to the industrial action that recently occurred in connection with One Growers Enterprise Agreement negotiations. Now, I appreciate that this type of media attention causes concern for other growers in the industry, and rightly so. Look, the UWU will use this as a recruitment drive. Nationally, union membership is at the lowest it's ever been in Australia. We're looking at around 8% in the private sector. The unions will use this particular publication as a good news story. Join the union, look what we achieve, look what we can achieve for you. So growers really need to be talking to their people, whether you're currently in negotiations or not, because at the end of the day, if your people are happy, they're less likely to pay a membership fee out of their wages to join a union. So what can you do on a practical level to engage your workforce during negotiations? As I keep saying, communication really is the key. Having a communication strategy for each step in the process, from the initiation of enterprise bargaining through to the approval of the agreement, can help employers communicate more effectively with employees and avoid any legal or practical hurdles. Use a variety of communication channels, including notice boards, the intranet, internal emails, and social media to communicate with your people. You can also conduct employee surveys and questionnaires. Doing this in the early stages of the bargaining process can assist you in testing assumptions or confirming what really motivates your workforce. Make sure that surveys are conducted at the right time, because this will often yield better results rather than a one-size-fits-all approach. For example, one workforce might respond well to an email survey, while others would prefer face-to-face meetings in small focus groups. As workplaces become more diverse, the one-size-fits-all approach may no longer be effective in communicating with employees. For example, a growing number of workplaces now have employees from culturally diverse backgrounds or employees who speak English as a second language. This means that an employer may need to explain the proposed agreement in simple English, or use an interpreter to explain the agreement, or even translate some of the materials and comms that you want to distribute. Last, don't be afraid to positively interact with your relevant employee representatives. So the level of cooperation or hostility that a business can expect from a union will often depend on a number of different factors, including past dealings, current employee engagement with the business, and the size and location of your business. Another question that I'm often asked is, do we have to negotiate with a union? And when does a union have a right to be involved in our negotiations? The simple answer is the union has a right to a seat at the table if the proposed agreement will cover even one of their members. A bargaining representative can be any of the following people. It can be an employer that will be covered by the agreement, a representative appointed by the employer. For example, if a grower appoints AiGroup to act as their bargaining representative. It can be an employee that will be covered by the agreement. It can be a representative appointed by the employee. So this can be anyone that they choose, from their lawyer to their best friend to their mother to their sister, anyone. And a union. Now, a union is always the default bargaining representative for their members. So we'll talk about in a bit more detail what that means. So a union automatically represents an employee if the employee is a member of the union and if the union is entitled to represent the industrial interests of the employee in relation to the work that will be performed under the agreement. And this is usually determined by the relevant union's constitution. However, the union won't be the employee's bargaining representative if the employee revokes the status of the union as their bargaining representative, or if they appoint another person or themselves as the bargaining representative for the agreement. So this means that during bargaining, an employee who is a member of the union may appoint their own bargaining representative, with the effect that the automatic appointment of the union will cease to apply. Enterprise bargaining often leads to concerns about unions entering your site and questions around union right of entry. Basically, when is the union entitled to enter my site? The Fair Work Act provides 3 reasons for the union to enter your site. They can enter to investigate a suspected breach of the Fair Work Act or an award or an enterprise agreement. They can enter to hold discussions with your employees, and they can enter to exercise rights under a state or territory WHS law. Now, when you have negotiations on foot or potentially upcoming, the unions will want to enter your site in order to hold discussions with your employees about the negotiations. Now, they can do this, but they need to follow the right of entry rules that apply under the Fair Work Act. First off, the union official must hold an entry permit. Now, permits are issued by the Fair Work Commission to union officials who are deemed to be fit and proper persons. They're valid for 3 years, and union officials need a federal permit to gain access to a workplace, even if they're entering on WHS grounds. Put simply, no permit, no right of entry. Now, I've included a link on the slide, and these slides will be made available to you. And if you click on that link, it actually allows you to check a permit. So if you have concerns as to the legitimacy of a permit that's been presented to you by an official, you can go online and you can check that and you can make sure it's still valid. The union can enter your site to hold discussions with employees. So the requirements are that the employees perform work on your site, they're members or eligible to be members of the union, and they wish to participate in the discussions. So a union can enter a site to hold discussions, even if no employees at the site are currently members of the union. However, they must be eligible to represent the employees' industrial interests. And as I said, this is usually determined by the union's rules, usually under their constitution. In order to enter your site and hold discussions with your employees, a union official must provide you with a formal entry notice. Now, on the next slide, I'm going to take you through an entry notice that I had, just so that you can see what you should expect on this document. The notice needs to be provided during working hours and at least 24 hours and no more than 14 days prior to the specified day of entry. It needs to state the relevant section of the Fair Work Act that's authorising entry. It needs to include a statement that the union is entitled to represent the interests of an employee who performs work at the site. And it needs to include a reference to the part of the union rules that gives them that right. So this is the form and content of an entry notice under the Fair Work Act. So I've blocked out some personal details there, but that's what you should be expecting on each and every occasion that a union enters your site for the purposes of holding discussions under the Fair Work Act. So are there any rules that a union official needs to follow when they enter your site? Yes, absolutely. When a union official enters your site to hold discussions, as I said, they need to give you 24 hours notice. They also need to show you their entry permit and their entry notice if you request them, and I would recommend that you do. They also need to comply with reasonable requests to adhere to WHS requirements or to meet in a certain room. So, for example, you can direct a union official to hold their discussions in a certain room or a certain location on your site. If a location can't be agreed to, by default, the meeting will be held in the room where employees take their meal breaks. The union can enter only during business hours and hold discussions only during meal times or other breaks. To be clear, the union are not permitted to hold discussions with your employees during paid work time. They can hold discussions only with those employees who wish to participate in the discussions. So if most of your workforce have no interest in spending their lunch break talking to the union, things will fizzle out pretty quickly. And they must comply with any route required by the employer to the nominated room. So this is an important one. Don't let the union wander around your site unchaperoned. And last but not least, there must also be an employee on site that the members are eligible to represent, or that the union is eligible to represent. Breaching the right of entry rules have real and serious consequences. If you subscribe to Workplace Express, you'll see that there are certain unions who are regularly fined for non-compliance. Penalties apply where union officials intentionally hinder or obstruct an employer or employees, where an employer refuses or unduly delays entry to a premises, and where an employer refuses or fails to comply with the requirement to allow an official to inspect or copy records or documents. All right. Knowing when to engage a professional to help with your enterprise bargaining process. Look, there are various options for outsourcing your enterprise bargaining process. For example, you can nominate someone such as a legal or IR specialist to act as your bargaining representative and effectively lead the negotiations on behalf of your business. So you'll still be in charge, you'll set the bargaining parameters for the business, you'll provide instructions, you'll attend all the meetings, but your representative will do all of the talking and all of the arguing for you. Another option is to engage an IR specialist to provide ad hoc support to your business as you need it throughout the course of bargaining. So, for example, you might seek a professional's assistance with all of the legal formalities that apply to the bargaining process, or to seek input with a strategy for managing contentious bargaining or threatened industrial action, those types of things. Okay, so I've managed to get through that incredibly quickly. I hope I wasn't speaking too fast, but it means we've got plenty of time for questions.
Thank you very much, Vikki. If anyone's got any questions, please feel free to type them into the Q&A down the bottom, or you can pop them in the chat as well. One's come through in the Q&A. Do employees, Vikki, have the right to check the union status of an employee? Does the employer have the right to check the union status of an employee, or does the employee just, I guess, say, yes, I'm a member, or can you actually check that they are a bona fide member?
Yeah, so that's a really good question. I understand that it can be difficult for employers to ascertain exactly who's a union member and who's not, because whilst in some cases you might be asked to deduct union dues from salary, that doesn't always apply. So in relation to your question, I assume that's centered on the protected action ballot process and wanting to know who will be on that roll of voters for the purposes of voting on protected industrial action. Now, in those circumstances, the applicant to the application, so the union, they will need to provide a list of eligible voters so that the commission and the employer and everyone who's party to the application knows who will be voting on the protected action ballot order, so that a determination can be made as to whether we have a majority vote or not. So yes, the answer to your question is, in the context of protected industrial action, the employer has a right to know who the union members are so that they know who will be participating in the vote, and in turn, if the vote gets up, who is authorised to take protected industrial action under that application.
Thank you, Vikki. There's no chat question. Oh, hang on, there's a question just coming through. Just confirming, if you have no employee that is affiliated with the union, you do not have to liaise with the unions.
In relation to negotiations?
Yes.
Okay. That's a really good question. So when it comes to initiating bargaining, issuing the NAIR, etc., look, if you have no union involvement, then from the get-go, I probably wouldn't be inclined to extend those forms of communication to them. However, as I said, if they have employees who can potentially be members of their union, they can subsequently come on site, hold discussions with them. If they then sign up for union membership, even one employee, then they have a right to a seat at the table. So I suppose that's the answer to your question. So long as they do not have a single member on site covered by that agreement or proposed agreement, no, they don't have a seat at the table. But if they have just one member, they're entitled to a seat at the table.
Thanks, Vikki. I have another one here which was sent through to me yesterday, and you may not be able to answer this one, but under the new PALM deed and guidelines, Pacific Australia Labour Mobility, it says in there that the government can allow certain entities to go and check accommodation, which of course can be unions. Do you know how that might work, or would that change, need a requirement to change to allow unions to come on to a property to check accommodation?
Yeah, I would have to take that one on notice. I'm not across that particular piece of legislation.
Yeah, okay. Thank you. That's
Sorry.
good. No, that's good. I didn't know the answer, so we might get some further clarification as well on that one. I have one here. Do employees have the right to display union pamphlets and signs, etc., around the workplace?
Yeah, look, that's a really interesting one, and a really good question. What we're seeing in the course of a lot of negotiations that are on foot at the moment is unions are pressing for express terms in enterprise agreements that authorise their members to have, for example, a union notice board on site, where they can display their union information, or alternatively, the right to post their information on the company's notice board. So we're seeing unions request those rights in enterprise agreements. Now, assuming you don't have an enterprise agreement dealing with any of that stuff, look, if you've got a common employee notice board in your lunchroom, sure, the union could post something on there, but if another employee was to take it down, or someone else was to take it down, well, look, I mean, it's a common notice board, right? There's no express right to retain some real estate on that in the absence of anything being spelt out in an enterprise agreement. On the note of sort of union colours and flyers and what have you, keep in mind something else that we see quite a bit is this. When it comes to protected industrial action, like I said, strike action isn't the only form of action. We see bans on overtime and that type of thing. Another thing we see is that employees will take action whereby they will continue to present for work and do their jobs, but they will not wear their company allocated uniform. They will only wear union attire with union logos on it. So that's another thing we're seeing, and that's the union trying to run this campaign and put that message out there. So yeah, that's another thing to keep in mind.
Right. Thank you, Vikki. We've got one here. How often does a small or medium-sized business who has very good staff relations get into trouble with unions?
Yeah, look, that's a good one. As I sort of said earlier, employers who have happy employees will generally have less union involvement. And the reason for that is happy employees do not feel the need to sacrifice a portion of their earnings to go towards a union membership because they're happy and content. If you have lower union membership among your workforce, you will probably have, well, you will have less union involvement. Now, that doesn't mean no union involvement. Every now and again, I've got a few members, for example, in the manufacturing industry who have very low or nil union membership. And every now and again, I'll hear from them and they'll say, look, I don't know what's going on. I'm getting right of entry notices. They're coming in, they're holding discussions. What do they want? And the answer to that is, well, look, it's a membership drive. They know you've got low membership on your site. They want to come in and chat to your employees and try and persuade them to join your membership. So to answer your question, if you've got good relationships with your employees and low union membership, you'll probably see smooth sailing for the large part. However, every now and again, don't be surprised if you get an entry notice because they want to come on site and hold discussions.
Great, thanks, Vikki. Next one, does the same process of escalation to industrial action apply to the new multi-employer bargaining? And could all affected employees be subject to one action?
Yeah, so that's a really good question. When it comes to protected industrial action for multi-employer bargaining, there are a number of different considerations that now apply under the Secure Jobs Better Pay Bill. So, for example, I referred to the 3-day notice period that employees must afford to their employers before they take action. That notice period is quite a bit higher. Off the top of my head, I can't remember the exact number, but it's quite a bit higher than 3 days. So there's that additional layer of notice that is afforded to the employer before that action can be taken. I think the other thing we would see with multi-employer bargaining is this. When we were talking about the very limited circumstances in which the Commission may intervene and grant an order to stop or cease protected industrial action on the basis that it's causing, a severe disruption or harm or threatening to harm the economy or what have you, I think, and this is my opinion, that when it comes to multi-employer bargaining, it'll be easier to potentially meet that threshold, because when you've got half the industry involved in multi-employer bargaining and the protected industrial action can potentially span across 2, 3, 4 work sites or farms in your instance, I think it will be easier to demonstrate that the action is having seriously adverse implications on a significant part of the Australian economy. So to answer your question, yes, look, when it comes to multi-employer bargaining, that protected industrial action does have the capacity to span across a number of different employers' sites.
Thank you, Vikki. Next one is, do employers have the right to delay union officials attending the workplace for reasonable reasons?
That's a good one. And look, no, if I just take you back to when we were discussing breaching the right of entry rules and the fact that there can be some pretty hefty penalties under those provisions of the Fair Work Act. If an employer unduly delays entry to a premises, so off the top of my head, I think that's section 502 of the Fair Work Act, you can be subject to a penalty. Now, I hear what you're saying. The person who's asked the question has said, well, hang on a minute. What about if there's a reasonable basis to delay their entry? Look, you would bear the burden of demonstrating that you have a reasonable basis. And I'd also be asking, what is a reasonable basis for delaying entry to hold discussions, for example? So they're the types of things that you need to be thinking about, and also bearing in mind, as I said, that if it's determined that you unduly delayed their entry, that can attract a civil penalty under the Fair Work Act.
Thank you, Vikki. Next one, if a union representative acts unlawfully, who do you report it to?
Yeah, look, that's a really good question. So there's a number of different reporting mechanisms. So if the entry is occurring under the Fair Work Act, so for example, if it's an entry to hold discussions or investigate a contravention or that type of thing, and your entry notice is served under the Fair Work Act, those types of matters can be notified directly to the Commission. So I don't think there's actually a particular application for that. I think you'd use a Form F1, and you can actually call it on to the Commission, and it's an application where you are effectively seeking that a person be penalised for taking a particular form of breach action under their entry permit, or alternatively acting outside the confines of their permit. If the entry permit relates to work health and safety, so it's an entry notice under the relevant state or territory work health and safety law, then you can report any contravention to your relevant regulator. So that will vary from state to state depending on where you are, but your work health and safety regulator.
Right, thank you, Vikki. The next one is, in the event that a business is not considering or negotiating an EBA, what rights do unions have to enter business premises? So no EBA negotiations.
What right do the unions have to enter when there's no negotiations on foot?
And no intent to negotiate either. Yeah,
that's a really good question. So we spoke earlier about right of entry under the Fair Work Act for the purposes of holding discussions. So another tactic that unions will adopt is this. If they can see not only that an employer doesn't have an agreement in place, but that their employees are generally happy, there's not much appetite among the employees or the company to have an enterprise agreement in place, they will exercise an entry notice under the Fair Work Act to come in and hold discussions during employees' lunch breaks. Now, they're entitled to do that whether or not you have an agreement in place and whether or not any of your employees are members. Your people don't even have to be members for them to enter to hold discussions. They just have to be eligible to be members. Now, they'll then come in, they'll hold their discussions during break times, and they'll use it as a recruitment drive. Come and join the union. This is what we achieved over at this farm. This is what we achieved for this company. We can get you these terms and conditions. If you join the union, we'll push your employer into an enterprise agreement. But again, as we said earlier, if you've got happy employees, they probably don't want to spend their lunch breaks talking to the union. They probably want to go and do other things. And the union can't hold discussions with your employees during paid work time. They can only do it during, break times or before and after. So that's another thing to keep in mind there. So to answer your question, look, if you don't have an enterprise agreement in place, can they still enter your site and talk to your employees? Yes, they can.
Yes, on that note there, Vikki, if you unions want to hold a meeting and you've given them a room, a good 500 metres walk from the lunchroom, yep. Where is that perfectly legal?
Perfectly acceptable. So the employer can delegate the location that the union will hold these discussions. You can allocate them either a room, or if you're a predominantly outdoor workforce, you can offer them a particular location, a particular space over here to hold these discussions. just keep in mind that in the event that the union raises a dispute and an agreement can't be reached as to where the location will be, the default location under the Act is the room in which the employees take their lunch break. However, as a starting point, absolutely, if you want to allocate them a room 500 metres away from the lunchroom, by all means, you're entitled to do so.
Thank you. Next question. Many field workers eat their lunch in the field. Do you need to provide the union rep access to your field? And what of biosecurity? So keeping that in mind.
Yeah, that's a really good question. And you've tapped into something that I find myself constantly emphasising to employers. Under no circumstances should you ever let the union wander around your site unchaperoned. If they have served a notice on you to come in for the purposes of holding discussions, you allocate them a particular room. Even if your field workers prefer to eat their lunch outside under the sunlight as opposed to in a lunchroom, well, that's the union's problem. That's not your problem. Those employees are welcome to come and eat their lunch in the room that you allocate the union if they so choose. If they would prefer not to and they want to sit outside, we don't have to grant the union access to our outdoor space where our employees are. On the contrary, we are entitled to chaperone them from the entry point to the room that we have allocated them and then back out again. And in fact, I'd encourage you to do so on the basis of your obligations under the work health and safety laws. We can't have people wandering around the site unchaperoned.
Thank you. What is the threshold burden of proof for proving that strike industrial action is economically harmful to the employer or employees' third parties? In reality, any industrial action will cause a grower to lose money and additional cause customers to lose money if they aren't provided produce.
Yeah, look, the threshold is high. It's very high. So look, in relation to a third party, I'll give you an example. So let's take a major supermarket. Let's take Woolworths. So say, for example, one grower was precluded from fulfilling their obligations to Woolworths under their contract in relation to oranges. They couldn't deliver any oranges to Woolworths for quite some time due to protected industrial action. Provided that Woolworths can still access oranges from other growers, whilst they might be suffering a small disadvantage in relation to what they're not receiving from that particular grower, on the whole, that third party isn't damaged because they're still receiving oranges from other growers. So in order for the threshold to be met and for a third party to suffer serious damage, in that circumstance, if we had multi-employer bargaining on foot and protected industrial action occurring across that landscape, and Woolworths was unable to receive oranges from any grower in the state, then I think that would meet the threshold. And look, similarly, in relation to a particular employer, as the person who asked that question said, any protected industrial action, even if it goes for one day, is going to cause financial difficulty to an employer. But the Act says that it needs to be protracted. So it needs to have occurred for a significant period of time. The other thing to keep in mind, particularly in the economic climate that we're currently in, look, where strike action is occurring, we're not seeing that it's protracted. We're seeing that it's rolled up in a couple of days because, you know, realistically, people can't afford to strike for longer than that. And sometimes the best option for a business can be to think about strategically, how do I ride out this strike? Can I train up other employees to do the job that my field workers were doing now that they're on strike? Can I train up my line managers, my supervisors, my people who usually work indoors to come outdoors and do this work just for a couple of days so that we can ride it out? Can we build up any stock where can we build up that stock? And I appreciate, given the industry that you're in, a lot of your stock, it simply can't be built up. It has, a limited life, but those are the other types of things to start thinking about.
Vikki, I guess in that case, protracted, is there a definition for it? Because I guess protected action for a widget manufacturer is different to protected action for a leafy green producer or something where the product shelf life is, only short. So is protected a set time, or is it relating to the actual industry?
Yeah, look, there is no set time. I wish I could point you to a time frame, but when the Commission does consider these applications on a case-by-case basis, they really are that. They're determined on a case-by-case basis based on the specifics of that particular industry, the particular employer, those employees. They're the types of things that will be thought about really on a case-by-case basis. I'm just trying to even think of any overarching principles, but off the top of my head, I can't point you to any kind of definitive time frame.
Thank you. What's the process to move from an expired EBA to the modern award?
Yeah, so that's a good one. So, as we know, an enterprise agreement that has exceeded its nominal term will continue to apply to your workforce until one of two things happens. One, you replace it with a new enterprise agreement, or two, you make an application to terminate that agreement. Now, if you want to move to a modern award, you would need to make an application to terminate that agreement. Now, the difficulty with these types of applications, when we're not intending to honour existing rates of pay, is that employees will have a pretty good case for saying, well, hang on a minute, it's not in the public interest for this application to be granted. Currently, I'm earning $30 an hour under the enterprise agreement. My employer is proposing to terminate that and take me back to the underpinning award, where I'll be paid $25 an hour. They're not proposing to honour grandfather or honour wage rates for existing employees. And so they're the types of considerations that will come into play there. And further, with amendments to the Secure Jobs, Better Pay Act that have flowed onto the Fair Work Act, there's a number of different considerations that will now come into play there to safeguard those types of entitlements that weren't previously there. So it's a different situation where, for example, an employer says, look, I'm going to terminate the enterprise agreement. I'm proposing to go back to the award. I've consulted with my employees. I've sought their views and opinions. They're all on board because we're going to grandfather their existing entitlements. No one will be worse off. We've spoken to the unions about it. They're on board as well. That's a very different application process to one in which an employer hasn't spoken to their employees, hasn't consulted with the unions, is proposing to sort of pull back rates so that they're in line with the award. People will be worse off. So to answer your question, look, you can do it. You can go from a terminated EA back to the award. You'll need to make an application to terminate the enterprise agreement. Whether that application is granted or not will depend on a number of factors, including the ones that I've just outlined.
Thank you. Next question. Do unions have the right to take photography or video footage under the right of entry?
Yeah, so that's a good one. Look, ordinarily no. So it depends if they are on site to investigate a serious suspected safety contravention. They could potentially mount an argument there. But ordinarily, no, if they're on site to conduct discussions and what have you, and they start filming around your workplace, I mean, depending on what state this is happening in, they could potentially be in breach of the relevant workplace surveillance legislation. In addition to that, depending on what kind of policies the employer has in place, they could be contravening those as well. Not to mention employee rights to privacy, depending on whether the surveillance is covert or not, and whether the employee is captured in the footage, consent to be within the footage. But ordinarily, no, it isn't a right to start walking around filming what they say.
Thank you. Do employees have the right to enter staff accommodation, such as farm accommodation, which is off-site of the farm?
Employees or unions?
Sorry, unions. Sorry, unions.
I'm not across the particular regulatory guidelines that apply to that type of accommodation. But look, it would fall on whether or not the accommodation is a workplace. Because if it's considered a workplace, then I would think right of entry rules would apply. On the other hand, if the accommodation is considered separate and distinct to the workplace, well, that's a separate matter. But as I said, I'm not across the regulatory guidelines that cover those arrangements.
Excellent. Are employers allowed to sit in on union discussions with staff?
Yeah, good question. So if unions have entered your site for the purposes of holding discussions and you've allocated them a room to speak in, yeah, look, quite often I'll have members who will say to me, look, I'm not particularly interested in hearing what's going on, but I don't want them wandering around the site once they've finished their talk. So what do you think about me pulling up a chair and sitting outside the room? And my advice is generally that I think that's a good approach. Stay on standby so that once they're finished, you can chaperone them back out again. Likewise, if you want to be in the room, there's nothing in the Act that prohibits your involvement and your observation, provided that you're not hindering their discussions or presentation in any way, you're not interrupting. If you're just sitting in the room, you're permitted to do that. Will that aggravate them somewhat? Yeah, look, potentially it will, depending on who the person is. If it's the head of HR sitting in whilst they're conducting their discussions with members or potential members, they probably will get their back up about it. And look, that's when you can make a judgment call as to whether or not it's worth, having that argument, or whether you're content to pick up a chair and put it outside the room and wait outside until they're finished.
Excellent. Thank you, Vikki. Employees with zombie agreements are not happy that they are expiring on the 6th of December. What is your view on Fair Work Commission and employee requested additional hours, not at overtime rates, being considered by the Fair Work Commission?
Look, that's a bit of a loaded question, one that I'd usually consider in a bit more detail. But look, at a high level, I will say this. You may have seen there was today a publication in Workplace Express where the Commission made it quite clear that when it comes to zombie agreements that are set to expire, and the right of the parties to request extensions to certain zombie agreements, the Commission have said, look, just because I've got an application before me saying that the employees want it to prolong and continue and the employer wants it to prolong and continue, that in itself isn't sufficient for the Commission to agree to extend the life of that zombie agreement. You need to give us other reasons for the requested extension. As to your question around hours and unpaid hours and overtime, look, I would need to look at that in quite a bit more detail to give you a considered view. I'm sorry.
No worries. Thank you, Vikki. Do we have any more questions? We've actually got to the end of the question queue. I don't think we have any more popping up. So on that note, I'll just give it a couple more seconds just to make sure there aren't any last minute questions. No, so that's all good. Thank you very much, Vikki, for the webinar today. It's been very helpful, particularly the Q&A afterwards. Oh, actually, hang on, can we have a copy of the presentation? Yes, we can easily do that one. That's easy. And I noticed someone also wanted a copy of that link that you put up before as well. So that will come in the slides, and we can distribute those out straight after the meeting today. So that'll be easy, and we'll have the webinar ready in a few days' time to go up as well. But thank you very much, Vikki, for today's presentation. And if anyone has any other questions, they can just get in contact with AUSVEG, and we will also distribute some FAQs and maybe incorporate some of those Q&As that we had at the end as well. So thank you, everyone. And thank you, Vikki.
Thank you, guys. It was great speaking with you. Have a good week.
Bye.